Welcome to Medical Law and Ethics, Chapter 6, Defenses to Liability Suits. Throughout this chapter, we will cover the following learning outcomes. We'll define the 4 C's, relating them to workplace precautions that help prevent medical malpractice lawsuits. We'll describe the various defenses to professional liability suits. We'll explain the purpose of quality improvement and risk management within a healthcare facility. And we'll identify 5 different types of medical liability insurance. Here's a list of key terms that we will cover throughout this chapter. Malpractice litigation adds to the cost of healthcare, and it takes a psychological toll on both patients and practitioners. Everyone would agree that prevention is preferable to litigation in a malpractice claim. It seems that healthcare practitioners who use reasonable care in preventing professional liability claims are the least likely to be faced with defending themselves against such claims. Some things physicians can do to avoid liability risks are carefully selecting and supervising all employees, and they should be careful in delegating duties to them, expecting them only to perform the duties within their scope and within their qualifications, credentials, and training. Physicians should exhaust all reasonable methods of securing a diagnosis before starting a course of treatment. Physicians should use the most conservative and least dangerous methods for both diagnosis and treatment whenever possible, rather than those that involve highly toxic agents or risky surgical procedures. Telemedicine has become way more common, and physicians often diagnose and prescribe medications over the phone or over the internet. To avoid lawsuits, all of these conversations, meetings should be properly documented in a patient's medical record. They should also make sure they know and conform to state and federal laws regarding telemedicine. In all situations, when a doctor is doing a physical exam, they need to have another employee present. Ideally, they would have a female employee present when examining a female patient and a male employee present when examining a male patient. This is not always possible, but at a bare minimum, they should have another employee present. Physicians and/or employers should be safety conscious and be frequently checking facilities and equipment to make sure things are operating correctly, there isn't any slip hazards, trip hazards, etc. The reception area should include a safe area for children, perhaps with books or child-sized tables and chairs. When diagnosis or treatment requires the use of toxic agents, physicians should know the customary dosages and usage for such substances, any possible side effects, and the treatment for any types of side effects or reactions. All hazardous materials need to be stored correctly with safety data sheets and proper instructions for use and handling. While we touched on patient safety standards briefly in the last chapter, I'm going to go back over these as they are an integral part of preventing lawsuits. Physicians should always be safeguarding patients while they're being examined or treated. Number 1, it's not even in this list, but number 1, ID your patient correctly. Make sure you're using 2 different patient identifiers, such as their name, date of birth. If you have to use a medical record number, make sure you're identifying your patient correctly. Most important thing for patient safety. Make sure patients receive the correct blood. On top of type and antibodies, there's a lot of small components that go into receiving the correct blood if they're getting a transfusion. Get the test results to the right person in a timely manner. So make sure that your patient has been identified correctly, that the right results are going to the right person on time. Make sure to label all medicines in all containers before a procedure. If you are transferring medication to a new container, make sure that that is labeled so everyone knows what is in it. Identify all medications a patient has taken. and compare to new medicines to look for reactions or side effects. Check alarms on medical equipment. Make sure they're working correctly, that they can be heard if it goes off. Use the CDC guidelines for hand cleaning. Use proven guidelines to prevent infections, blood infections from central lines, and infections after surgery. Make sure that you're identifying suicidal tendencies in patients. And make sure that you're performing the correct surgery on the correct patient in the correct place on the patient's body. Here's a list of the 4 C's of medical malpractice prevention: caring, communication, competence, and charting. Caring. There are 2 major benefits in showing your patient your care. First, their medical condition is more likely to improve. And second is there's less likelihood that they'll need to sue if treatment doesn't have the results they are expecting, or if adverse events occur. Of course, you want to be sure to be sincere in this caring, because insincerity is going to make patients less likely to trust you. Communication. You want to use active communication. You want to communicate clearly and ask for feedback to make sure that there is a level of understanding from your patients. If your duties include taking telephone messages, relate them accurately. Competence. Make sure that you are well versed in your area of specialty. Make sure that you know your limitations. Follow standards of care and appropriate procedures. By knowing your limitations, you'll be able to avoid being in circumstances or actions you are not fully trained or equipped to handle. Work on maintaining and updating your knowledge and skills. Consult with other practitioners when you need to. Know the requirements of good medical practice. If you prepare or administer medications, double and triple check. Make sure that you are giving them the right dosage, the right medication. Anything out of date should be discarded. And stay informed about general medical and scientific progress by CEUs, reading professional journals, attending seminars. You always want to be moving forwards, keeping your thoughts and knowledge fresh with current society. And lastly, charting. Documentation is proof. For legal purposes, I've said this multiple times already in this course, if it isn't in writing and documented, it didn't happen. Medical records should include x-rays, progress notes, anything else that relates to the patient's medical treatment. And you always want to document as if the patient may read his or her medical record. Never write something that you would not want the patient to know you had written down. So again, the 4 C's of medical malpractice prevention are caring, communication, competence, and charting. Why do patients feel the need to sue? Sometimes they're unhappy with their diagnosis. They feel it was incorrect or ineffective. They suffered an abnormal injury during the surgery or procedure. They feel that the treatment was ineffective or incorrect. There's poor documentation of patient instructions and education. Sometimes there's errors in their medication administration. They were given the wrong dose or the wrong medication. They don't feel they were given enough aftercare instructions. They weren't given the correct steps to be successful following leaving the hospital. They feel there was a failure to follow safety procedures, the regular standard of care. Or lastly, improperly obtaining or not obtaining informed consent before a procedure. Some additional reasons patients sue involve patients wanting answers that physicians won't give, patients having billing questions, patients believing that details are missing from the records from their communications with the physician. Some patients sue out of desperation. Medical injury devastates a family financially or emotionally. Suing is their only recourse. Patients react to physicians' actions. So if a physician is very cold, seems uncaring when he talks to you about a really horrible situation, those patients are more likely to sue. So you can see how communication is vital to good patient relationships. Some things you can do to improve your communication skills are develop good listening skills. At our facility, we use what is called commit to sit. Take the time, sit down. Don't make the patient feel like you're trying to leave the whole time you're in the room. Another thing you can do is set aside a certain time of the day to call patients back, provide advice. That way they know they're going to get a return phone call. Thoroughly explain illnesses and treatment options. So you want to explain both the risks and complications, and you want to make sure that the patient understands these portions. While we encourage them to ask questions, sometimes you need to have that feedback to where you know they understand. Make sure informed consent forms are signed. So just like the previous part, they need to be informed, which means they need to understand both the benefits and risks of all procedures. Avoid any statements admitting fault. Use tact, good judgment, and professionalism with patients. So you want to be professional in your consultation, even if they are unhappy. You want the family to be able to feel like they can talk to you. Refrain from overly optimistic statements. Don't walk in the room and tell them, oh, you're going to be better in no time. You want to be realistic in what they should expect. You want to advise patients if the physician's going to be gone for a long period of time. Make sure that they realize he's on vacation or something else and they will not be receiving a callback. And lastly, you want to reach an understanding about the fees and costs of a treatment before you start, so it doesn't become a point of contention. And here again is documentation. If I haven't said it in every lecture, I'm going to say it again. If it isn't written down, it wasn't done. Documentation needs to include details, it needs to include conversations, it needs to include medications, levels, everything. Your medical record could be subpoenaed for a court case, and you want it to be thorough and all-inclusive. Realistically, if it's not in there, you can't prove that it was ever done. Moving on to the types of defenses in liability suits. Firstly, we have denial. Denial is a defense that claims innocence of the charges. You want to be 100% innocent if you are going to do a denial as your defense. If some of the alleged facts are true, then you should claim that the charge or charges do not meet all the elements of the theory of recovery. In other words, the charge may be missing one of the 4 Ds of negligence. And those are, if you don't remember, duty, you owed them a duty of care; dereliction, you breached the duty of care to the patient; damages, there was an actual injury; and the direct cause, the breach of duty of care was the cause of the injury. Affirmative defenses claim that while they'll acknowledge there was an injury, there was some other factor than the defendant's negligence that caused the injury. In contributory negligence, the physician would be claiming that the patient contributed to their own injury, whether it was a failure to follow post-procedure protocol or taking the appropriate medications. They are going to claim that the patient had an active part in their injury. Comparative negligence, on the other hand, puts it in a percentage. So it may be that the doctor was 75% to blame for the injury and the patient was 25%. In comparative negligence, because both parties shared a percentage of the negligence, damage awards will only be awarded to the percentage of the doctor's portion. In assumption of risk, the patient is aware of and understands the risk level involved and assumes that to be able to do the action on their own. These involve things like undressing for an unstable elderly patient. They have refused assistance. They want to do it on their own, so them falling while undressing would not be considered the doctor's fault. And the last affirmative defense is emergency. In order to claim emergency, the doctor or physician would need to prove that a true emergency existed and was not caused by the defendant. They also would have to prove that the appropriate standard of care was met given the emergency situation. So they need to prove that they helped and didn't hinder in the situation. This is also known as the Good Samaritan Act. When defenses to liability suits are based on legal technicalities instead of evidence, they are called technical defenses. The first of these is release of tortfeasor. So if you remember from previous chapters, the tort is an injury or a wrong, and the feasor is the person guilty of inflicting that injury or wrong. So a release of tortfeasor means there's multiple parties inside of a lawsuit. If the plaintiff settles with the first case and does not expressly reserve the right to continue to sue the other parties, they are cleared of wrongdoing because of the initial release of tortfeasor from the initial case. Because the plaintiff has already received restitution for this action, for this injury, they no longer can sue the additional parties. Res judica, or the thing has already been decided, is a legal principle that a claim cannot be retried between the same parties if it has already been legally resolved. So an example of this would be a physician sues a patient for not paying their bill. The patient claims that they have not paid their bill because the doctor was negligent. If the doctor wins their case and the patient has to pay their bill, they cannot turn around and charge that physician for negligence. They cannot reuse the same information or information that has been brought out in the first case against them in another case. It has already been tried and decided. And lastly, the statute of limitations. For most malpractice suits, the statute of limitations is 2 years, but between different states can range from 1 to 6. The statute of limitation puts a limit on the time period during which a lawsuit may be filed. If it extends past that time frame, they no longer can file a suit against that physician, facility, etc. Different states also have different limitations on the beginning of that statutory period. For some states, it's the day the alleged negligent act was committed. For others, it's when the injury was discovered or should have been discovered. And lastly, it could be the day their physician-patient relationship ended or the day of the last medical treatment in a series. These limitations can usually be found in state code, published online, or in most public or university libraries. Risk management. Because liability has become such a major factor in healthcare, and because everyone is looking to minimize liability, risk management has become a necessary practice. Risk management can be defined as the taking of steps to minimize danger, hazard, and liability. It may reduce the possibility of lawsuits, and it involves identifying problem practices or behaviors, and then using critical thinking and problem solving to eliminate or reduce those problem practices or behaviors. Some of these things can be having very defined roles and making sure we have written steps and proper procedures in employee handbooks. Quality improvement and quality assurance are programs used to uphold the quality of patient care and reduce liability risk. Quality improvement plans usually involve the same process in healthcare as anywhere else. First, you want to identify the areas where improvement is needed. Second, determine which data to collect to find out if improvement has been achieved. Third, decide which changes will create the most improvement with the least amount of effort. Fourth, implement the action. And fifth, evaluate the results. Was there improvement given the new conditions? All of these things also need to include a compliance with federal, state, and local laws. Any improvements can't step outside of those boundaries. Professional liability insurance. So liability insurance is the contract coverage for potential damages incurred as a result of a negligent act. The liability insurance in healthcare would cover costs of defending a medical malpractice lawsuit up to the policy limit. So if they have a $10 million policy, that's as high as the insurance company will be willing to pay. If the settlement is for more than that, that is where the insurance company maxes out. The cost of their insurance is based on the physician's specialty and or the dollar amount of the policy. So a general practitioner or a family doctor is going to pay less for their liability insurance than a surgeon or a specialist. Anyone who performs surgery or procedures of that type is always going to pay more for their insurance. And then the amount of the policy will dictate the premiums in order to keep the policy. When premiums for a policy become too high, some physicians will be tempted to drop their liability insurance. However, this can adversely affect their practice because most hospitals require proof of coverage, and most managed care organizations, or HMOs, require them to provide proof of liability insurance as a prerequisite for entering into the contract. Medical malpractice insurance comes in two types, the first of which is claims-made insurance. This covers the insurer only for claims that are made while the policy is in force. It does not cover injuries occurring during the policy, just if the claim is made while the policy is in force. The opposite side of this is occurrence insurance. This covers the insurer for any claims made for injuries that occurred while the policy is in force, regardless of when the claim is made. So to reiterate this, claims-made insurance only covers between the start and end point of the policy for the claims made during that time period. And occurrence insurance covers for injuries occurring between the start and end point of the policy, regardless of when the claim is made. Because claims-made insurance only covers claims and not when the occurrence of something happened, they also offer extended coverage insurance if you end your coverage with a particular carrier. The first of these is tail coverage. This is bought from your prior insurance agency, and it covers the time frame much like occurrence insurance. It will continue to cover the time frame that the insurance was in effect. The opposite side of this is prior acts insurance coverage, or nose coverage. And this is bought from your new carrier and insures you for things that happened prior to your current insurance coverage. Typically, when starting a new claims-made insurance coverage, one of these two, either tail coverage or prior acts coverage, is required to purchase your new policy. Another form of insurance for doctors is self-insurance coverage. Inside of self-insurance coverage, the insurance company would write a policy with a limit of, let's say, $10 million. And the insured party or physician will contribute to a trust fund up to a limit of $10 million to be used in paying potential medical malpractice awards. The insurance company charges fees for managing the fund and for providing the insurance. One great advantage to self-insurance coverage is the premiums are considerably lower than traditional types of malpractice insurance. The disadvantage to it, though, is that state laws regulating insurance do not always allow such plans. And even some states where such coverage is allowed, hospitals have to agree to accept it because they only have a limited fund for payment. The reality of today's society is not if you are going to have a liability suit, but when and to what extent. Thank you for joining me for Chapter 6 of Medical Law and Ethics, Defenses to Liability Suits.